Hello, I'm Attorney Vince Davis. Today we're going to discuss the complexities of DUI laws in California and what you need to know if you're facing charges. A DUI arrest can be a life-altering event, but understanding the legal landscape is the first step toward protecting your future and your freedom. In California, it's illegal to operate a vehicle with a blood alcohol concentration of 0.08% or higher for most adults. For drivers under 21, California enforces a zero-tolerance policy where a BAC of just 0.01% can lead to a license suspension. What many people don't realize is that a DUI involves two separate cases, one with the DMV and another in the criminal court system. You only have 10 days from the date of your arrest to request a DMV hearing to prevent your driver's license from being automatically suspended. The DMV hearing is strictly about your driving privilege. It doesn't determine guilt for the crime, but it is a critical hurdle to clear. The criminal court case, on the other hand, deals with potential jail time, fines, and the permanent record of a DUI conviction. For a first-time DUI, penalties typically include substantial fines, a 3 to 9 month DUI school, and several years of informal probation. Penalties increase significantly with each subsequent offense within a 10-year period, often involving mandatory jail or even prison time. Factors like excessive speed, having a minor in the car, or causing an injury can trigger sentence enhancements that lead to much harsher punishments. If you are pulled over, it's vital to remain calm and polite. You have the right to remain silent and should exercise it respectfully. In California, field sobriety tests, like walking in a straight line, are generally optional. You can decline them without a direct legal penalty. The preliminary alcohol screening or PAS test at the roadside is also optional for most drivers, though refusing it may lead the officer to arrest you. Once you are arrested, however, California's implied consent law requires you to take a blood or breath test. Refusal here has major consequences. Refusing a chemical test after a lawful arrest leads to an automatic 1-year license suspension with no possibility of a restricted license. Every detail in the police report matters. We look for errors in the officer's observations or deviations from standard testing procedures. Breathalyzers and blood tests are not infallible. They must be calibrated and administered correctly, or the results can be challenged in court. A common defense is rising blood alcohol, where we argue your BAC was below the limit while driving but rose after you were stopped. If the officer didn't have a valid legal reason to pull you over, much of the evidence against you might be suppressed or thrown out entirely. Every case is unique. Developing the right strategy requires a deep dive into the technical and procedural aspects of your specific arrest. A DUI conviction can also impact your professional licenses and employment opportunities, especially if your job involves driving or security clearances. For commercial drivers, the stakes are even higher, with a much lower BAC limit of 0.04% and stricter license penalties. Beyond court fees, expect your car insurance premiums to rise dramatically, often requiring an SR-22 filing for several years. Remember, DUI isn't just about alcohol. You can be charged for driving under the influence of prescription medications or illegal drugs as well. Drug-related DUIs are often harder for the prosecution to prove because there is no standard limit like 0.08 for most substances. You might be tempted to handle this alone, but the legal system is complex and the prosecution is focused on getting a conviction. An experienced attorney can often negotiate to have charges reduced to a wet reckless or seek alternative sentencing to minimize the impact on your life. We conduct our own investigation, interviewing witnesses and reviewing video footage to ensure your side of the story is fully heard. Our goal is to give you peace of mind during a stressful time by providing clear communication and a strong defense every step of the way. The clock starts ticking the moment you are arrested. Taking immediate action is the best way to protect your driving rights and your record. If you or a loved one are facing DUI charges in California, I invite you to call my office today for a consultation. Don't face this alone. Call us at 888-888-6582. We're ready to stand by your side. Thank you for watching. Remember, knowing your rights is your best defense. Stay safe on the roads.